The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a .20. If I remember correctly, this is a DWI, and there's a fatality as a result.
Yes, sir.
Can you please read to me what happened?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a four-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact, massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with a HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler, and the driver of the Amazon truck confirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol on her.
Opening scene. The lawyer frames the case bluntly. The only thing she did wrong, drive a vehicle with cocaine, alcohol in her system. Right away we get the stakes, a DWI that ended in a fatality. The transcript moves fast. Crash time, location, and a firefighter witness who says the Chrysler cut in front, then clipped an Amazon truck. Reaction. That opening line lands like a punch. Admission of substances, plus eyewitness accounts. Yes, heavy evidence. Question for viewers. Who do you think bears primary responsibility in that split-second chain of events? The driver who had substances in her system, or the driver who spun out in front of her?
Breath, red glassy eyes, and slurred speech. She was transported to the hospital, and a DRE arrived, and she was Mirandized, and she waived her rights. She stated that an SUV was stopped in a lane, and she tried to swerve to avoid hitting it, and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving.
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze nystagmus, and officers observed a lack of convergence.
The medical and physical evidence pile up. The complainant is taken to the hospital and pronounced dead. Officers find an unopened beer can in the driver's seat. The defendant smells of alcohol, has glassy eyes, slurred speech, and later a blood result showing 0.025 ethanol plus marijuana and cocaine. The narrator matter-of-factly reports HGN results and that some field tests couldn't be completed because of injuries. Dramatic call-out. The scene mixes forensic detail with human tragedy. It's easy to read the numbers, harder to reckon with a life lost. Engagement prompt. Seeing the BAC and drugs listed, does that change your judgment of intent or culpability?
They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done, and her blood, Your Honor, came back at.
Negotiations surface. The prosecution offers an 18-month probation deal with 7 days as a condition, and the judge erupts. You have a dead body here. A week in jail is insufficient. This is a theatrical pivot. Courtroom morality versus legal technicalities. Reaction. The judge's anger is raw and understandable. He keeps circling back to the dead victim and the emotional weight that legal labels, DWI versus intoxication manslaughter, can't erase. Transition hook. The court acknowledges a legal gap, causation, that prevents a harsher charge, reopening the debate between law and moral outrage.
A .025 for ethanol, and she had, yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's the offer that you have worked out?
We worked out an 18-month probation offer with 7 days as a condition.
The judge focuses on consequences. Look at me. While you're about to give life, you took someone else's life. That line is searing, juxtaposing pregnancy with the loss of another family's life. The judge asks how many lives are ruined now. The answer is obvious, many. Commentary reaction. This is where the human story overwhelms procedural talk. Viewer question. Does the defendant's pregnancy change how the court should punish? Should it factor in mercy, or is justice blind to circumstance?
Your Honor,
That's not the fact that there's a dead body in this case. Why is it not an intoxication?
it's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not sorry, I'm not going to take the You have a dead body here. She has cocaine in the system. She's got.
Defense pushes back. The crash may have been unavoidable because another vehicle spun out in front of the defendant. Then the transcript shifts into a detailed aside. An attorney, or ex-officer, recounts breath test training labs and anecdotes about blowing 0.14 after heavy drinking, trying to contextualize the defendant's 0.025. Dramatic note, this is a classic courtroom tug-of-war, competing narratives, unavoidable accident versus impairment, attempting to tip the scales. Engagement prompt. When you hear unavoidable, does that settle reasonable doubt for you? Or do prior admissions of alcohol and drugs still weigh more heavily?
Who's in the car while she's driving in a dead body? I'm not down with that. No, we're going to have to do something else, but I would be remiss a week in jail where we have a dead body.
Yes, sir.
There's a brief, almost surreal rhythm break. Confusion over the BAC numbers, some music markers in the transcript. Then the record returns to the case. The mix of technical forensics, BAC math, and human testimony, injuries preventing field tests, underlines how messy real-world evidence can be. Reaction. Small errors or misunderstandings about numbers can become huge in court. Quick summary, evidence exists, but interpretation is the battlefield.
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. How many lives are now ruined because of this?
Now we return to the ethics question. Should jail time be served while the defendant is pregnant? Is that cruel and unusual? The judge wrestles with fairness. A dead body is a brutal reality, but so is punishing a pregnant person. This is the courtroom at its most conflicted. Call out. The judge doesn't dodge hard questions. He forces the room and the audience to confront competing forms of harm and the awkwardness of proportional punishment. Viewer poll idea, vote. Immediate jail, delayed sentence after birth, or alternative rehabilitation?
Yours. How about everybody else? Every single day in Harris County, someone is maimed because of the DWI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication manslaughter. But to me, a week.
The judge warns about long-term consequences. Drug use during pregnancy could lead to developmental and psychological issues for the child. You're guaranteeing yourself a life of babysitting. Then the court lays out the statutory penalties for DWI, up to 6 months and a $2,000 fine, but the agreed deal is 30 days as a condition of 18 months probation. Reaction. The judge is both scolding and administrating. Emotional reality checks followed by a procedural roadmap. Transition. We move from moralizing to the concrete terms the defendant must meet.
It's insufficient. It's not enough.
Yes, sir.
So
We'll go back to the drawing board and get
go
a
back,
reset, Judge.
but
Yes, sir.
I'm ready to set this case for trial now. So unless we can work something out today, I'm saying it gets set today.
Yes, sir.
Okay.
All right, thank you, Judge.
Your Honor, I understand that a fatality did occur, but the reason why they weren't able to charge my client with intox manslaughter is because this accident was unavoidable. If you were
Unavoidable?
yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle.
This segment lists the court-ordered conditions: DWI education, victim impact panel, ignition interlock, no refusal, wash, no drugs or alcohol, random UAs, 80 hours community service, and a $300 donation. The judge insists on strict monitoring and warns of warrants and up to 180 days if non-compliant. He also outlines the immigration risks if the defendant isn't a citizen. Commentary. The sentence reads like a rehabilitation contract mixed with a threat. Accountability plus supervision. Engagement question. Do you think these conditions are sufficient to protect public safety and serve justice to the victim's family? Video 10-012-12. Professional overview and final ruling. Wrap up VO. Final logistics. The defendant says she's due August 20th and asks for the jail time to start January 2025 so she can nurse. The judge allows flexibility but insists everything must be completed within 6 months. The defendant pleads. The transcript shows confusion over guilty versus not guilty, then a guilty finding and sentencing to the agreed deal. Professional summary. Legally, the case resolves as a DWI conviction with probation and 30 days custody as a condition, not manslaughter, because prosecutors could not prove causation beyond reasonable doubt. Broader implications. This transcript captures a fracture point in criminal justice. Strong emotional demand for harsher punishment meets evidentiary limits. The result is a negotiated sentence focused on monitoring and rehabilitation rather than a homicide conviction. Final reaction. Whether you feel justice was done will depend on whether you prioritize strict moral retribution or the legal standard of proof that protects against overreach. Call to action. Closing VO. If this courtroom scene raised questions for you, drop a comment. Who do you think is in the wrong here? Would you have ruled differently? If you found this breakdown useful, like the video, share it with someone who cares about criminal justice debates and subscribe for more courtroom breakdowns. Want a follow-up deep dive into how causation is proved in DWI manslaughter cases? Say the word and I'll make it next.
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. It gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense, guilty or not guilty? I will find you guilty. We'll send you to this agreement. Good luck to you, ma'am. Please see the clerk. Right, I'll let her choose a date. She has up to 6 months. Okay. Good luck, ma'am. Please see the clerk.
How many days is she doing?
30.